Hi, welcome everybody to another of our medical legal webinars where we cover some interesting topics which are quite relevant to your practice. And before I introduce the speaker, I just want to go through some housekeeping announcements. So, first of all, I think you're all very interested in the CPD point, which is you can claim for this talk. And there are two ways. If you're watching it live, we will display a QR code at the end of the session. Okay, now the QR code is valid only for 1 hour. So if you're watching on a laptop or an iPad, you can use the MMA app and scan for the point. Okay, now the good news, which I've mentioned in the Docs forum, is that a lot of you had this pain point where you're watching with a mobile phone and you cannot scan the QR code because the MMA app is in the same device. So if you have updated your MMA app to the latest, what you can do is take a screenshot of the QR code once it's displayed, save it onto your photo gallery, and the when you open the QR, the MMA app, and you go to the scan section, you'll notice at the bottom right, you can open the gallery and you can now scan the QR code as an image from the gallery. So that saves a lot of heartache for you guys who can't scan live and you're watching on your one and only device. Now, after the 1 hour validity has expired, and if you're watching, say, this talk 1 day, 2 days, or 3 days later, you can go to the MCQ module, which is linked below the video in our webpage, docs.my/medicolegal CME. Let me show you the page. So you can see if you're watching on this page, the video is embedded there. And on the right, we have the Slido embedded as well. So you can ask your questions in Slido, but the questions will be only answered after the talk is over. Now, below the video, you can see how to claim CPD points after the live stream and after the 1 hour validity is over. So for the doctors, you can click on link to CPD points module, and that will take you to the CME board, which I'll just show you here. Okay, that's our forum. So you need to be a registered DOPS member to get into the forum. You don't need to be a registered member to actually watch this live stream. This live stream is open for all, and you can just scan the QR code. So if you click on consent to medical practice, and then there will be a link to the MCQ module, which looks like this. Okay. You may have to re-log in, but it should be able to recognize that you've logged into the forum. And then you can watch it again if you want. But you can see in the red bar at the bottom, there's a solve online, and you just answer 3 simple MCQs to claim the points. Okay, just a reminder, you only need to do this if you are not watching live. Okay. All right. I'll just get back to the tab. So for the dentist, there is a link to register for CPD points for dentists. It takes you to a separate form which you register that you've watched, and that is handled by the Private Dental Practitioners Association. All right. So I hope that's clear. You can ask questions later at the end if you still don't know how to claim the point. Okay. For Q&A, you can use the YouTube live chat. All right. Which, if you're watching this directly on YouTube, if you are watching this on our webpage, you can see there's a Slido uh, Q&A platform. So this QR code here is not the QR code for CPD points. This QR code is for you to get onto slido.com. Or if you have the Slido app, you just enter 3720529 later on when you want to ask questions. But again, we'll answer your questions at the end of the session only. Okay. Please do like and subscribe if you enjoy this sort of webinar from us. Okay. Right, let me get back to this. Before I proceed, we'll wait for more people to come on board. So what I'll do is just have a little brief word from Dr. Shield, who have been kind enough to organize all our speakers and this medical legal series. So just a short word from Dr. Shield.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Okay, thank you for staying with us. So now I'm going to start the talk, and the presenter is Puan Fazliza binti Asli. She's an advocate and solicitor and partner at Chan Bang Eng and Co. She's talked to us before, but this time the topic is different, and it should be of interest to all doctors and dentists, because it's about something we do every day, and that's taking consent in our medical practice. In fact, I think this topic has generated quite a lot of interest, and even some nurses and so on, who also are part of the consent taking procedure, are interested to watch, and they're all welcome to watch. Okay, now this is a pre-recorded talk, so I'm going to stream Puan Fasliza's pre-recorded talk, and then at the end of it, I will bring her on stage, and then we can start the Q&A only after the talk. The talk is not very long, about 20 minutes only, and then we're going to spend more time in this session for the Q&A, because I'm sure you all have a lot of questions on the consent in medical practice. Okay, so starting shortly.
Hi, good evening, everyone. Thank you, Dr. Allen, for the introduction earlier. Before I proceed with my presentation today, I wish to introduce my managing partner, Mr. JJ Chan, who may be joining us later for the Q&A segment. Mr. JJ has a vast experience in civil litigation, with particular experience in medical legal matters, insurance and reinsurance law, directors and officers liability, corporate, etc., and so on. And he has been involved in a number of landmark cases, and he has written several books and commentaries ranging from topics on medical negligence to directors and officers liabilities. On the screen now, you can see the brief profile of my managing partner, Mr. JJ Chan. All right. Without further ado, I shall proceed with my presentation today on the consent in medical practice. So the first issues that we are dealing with is on the definition of consent. What is consent? Simple terms based on Cambridge Dictionary. In short, consent basically to agree to do something or to allow someone to do something. And based on the Malaysian Medical Council guideline, consent is the voluntary acquiescence by a person to the proposal of another, actual willingness that an act or an infringement of an interest shall occur, a person who possess and exercise sufficient mental capacity to make an intelligent decision demonstrates consent by performing an act recommended by another. Consent refers to the provision of approval or assent, particularly and especially after thoughtful consideration. Generally, no procedure, examination, surgery, or treatment may be undertaken on a patient without the consent of the patient if he or she is a competent person. Such consent may be expressed or implied and may be verbal or in writing. Now, who is responsible in obtaining consent? Under the guideline of Malaysian Medical Council, consent generally to be obtained by the medical practitioner who is a fully registered medical practitioner who would be performing the procedure, examination, surgery, and or treatment. And in cases involving joint management of care, the final responsibility and liability will rest on the practitioner who performs the procedure, who should, before performing the procedure, confirm the nature of the information given to the patient by the other practitioner in the course of taking the consent. So we have dealt with what is the definition of consent and who is responsible in taking the consent. Now, I'm going to discuss on the validity of consent, the duration, how long would it be valid under the law, and also based on the MMC guideline. According to the MMC guideline, consent is to be taken before an invasive procedure and remain valid as long as the patient's conditions remain the same. However, there are three circumstances where a fresh consent should be obtained from the patient. Firstly, when there's a change in the nature and clinical cause and presentation of the illness for which the consent had initially been obtained. Second circumstances is where there's a change in the circumstances or condition of the patient requiring a review of the procedure initially planned. And third circumstances is when the procedure is delayed or postponed, including and especially when an inpatient being discharged or a new consent has to be taken before undertaking the procedure. Examination, surgery, or treatment as the circumstances or the disease or the condition of the patient may have changed during that period, or the patient may not remember the details of the consent. I understand that it is sometimes the practice of convenience in many healthcare facilities or for the doctors for consent to be taken when the patient is being seen in the clinic by the practitioner and while scheduling the procedure or treatment, which may be in a week's time or later. In such instances, when the patient is seen on admission at the time before the surgery, it is best to remind the patient about the proposed procedure, surgery, treatment, or examination, and salient points in the consent from previously signed by the patient or take a new consent. Although the guideline from the MMC mentioned that consent will be valid as long as the patient's condition remains the same, but under the law, the deeming provision for a reasonable period of time would be within 7 to 14 days. So I would recommend in the event that consent was obtained between 7 to 14 days prior to the procedure being conducted, it is wise for the doctors to obtain a new consent from the patient. Okay, now I shall move the features of a valid consent, where there are actually 5 features for a valid consent to be formed. Firstly, the consent, it must be voluntary and personally given. It is important to note that in certain cases where the patient is capable in giving consent, but the relative or the next of kin are closely or dominantly involved in the decision-making process. In such circumstances, the practitioner should ensure that the consent is actually obtained from the patient directly and not from the dominant person. Medical practitioners should also try to ascertain the relationship between the patient and the accompanying person, whether the person is a legal guardian, relative, or etc. And such, the so-called the investigation process should be noted in the consent form in terms of the relationship between the patient and also whoever is there during the decision-making process. So the second feature in obtaining a valid consent is that it must be an informed consent, where patient must understand the effect of consent given, and there must be a consensus of mind in terms of giving the consent. The doctors or the healthcare personnel have to explain and advise the patient on material risks, potential side effect, complication, and alternative of any proposed treatment, procedure, surgery, etc. during the process of obtaining consent. And that explanation ought to be in a language that the patient understands. The third feature in obtaining a valid consent is that it must be in a written form and also recorded, which is in which this is actually consistent with the provision of the Private Healthcare Act, Regulation 47, subsection 3, where it is provided that consent obtained or caused to be obtained under this regulation, which is Regulation 47 of 3 of the Private Healthcare Act, shall be in writing. And the fifth feature, in order for a consent to be valid, is that it must be witnessed or that it must be a witness or interpreter who be. It's either must be witness or there must be an interpreter, and that witness, if at all, it can be another registered medical practitioner or a nurse who is not directly involved in the management of the patient, nor related to the patient or the medical practitioner, or any such person who can speak the language of the patient to attest to the process during taking of the consent. This element is quite important. Reason being, like mostly in medical legal cases, apart from the negligence on the care management, the patient would usually raise the issue of consent, meaning to say that, first of all, they're saying that they don't really understand what was being explained to them. And, that the explanation given was not in the language that they are comfortable with. And in that circumstances, we are of the view that it is very, very important for each and every consent taking process that someone to be a witness. In the event that the matter is escalated in the court, then we need to call the nurses or the other registered medical practitioner to basically testify in court to say that this is how consent being taken for this particular patient in respect of this particular treatment or surgery. So that's the reason why the fifth feature, i.e. on the witnessing and also on the interpretation, is really important. All right. Apart from that, the other main feature would be the patient must have mental capacity or legal capacity to give a consent. For cases involving a minor, which is below 18 years old, consent is to be obtained from the parents or from the legal guardian of that particular minor. And the medical practitioner need to ascertain the relationship between the patient and the accompanying adult and should defer treatment unless in life-saving procedure. Usually, consent from either parents is sufficient unless there's a court order which provide otherwise, example in custody order. This is where it involves a minor with a divorced family, where the practitioner needs to determine who has the custody of the child, whether the mother or the father, right? Then for consent involving individuals who are incapable or impaired with a decision making ability, under the MMC guideline, for elective or non-emergency operation, it is deemed necessary that the consent is obtained from a medical practitioner where there's a relative, next of kin, or legal guardian available, and relationship is well established or confirmed that the consent may be obtained from such a person. For those who are having mental issues, for example, there's a provision under Section 77 of the Mental Health Act 2001, where it is clearly stated that consent is generally not required for conventional treatment apart from surgery, electroconvulsive therapy, or clinical trials for patients with mental disorder. Whereas for surgery, electroconvulsive therapy, or clinical trials in an emergency situation, consent by guardian or relative of the patient, or if guardian or relative is not available or traceable, consent basically can be given by two medical officers or two registered medical practitioners, one of whom shall preferably be a psychiatrist. And in a non-emergency situation involving surgery, electroconvulsive therapy, or clinical trials, consent by the patient himself is required, or if not, by his guardian or relative, if patient is incapable of giving consent, and again by two psychiatrists, one of whom shall be the attending psychiatrist, and if there's no guardian or relative of the patient available or traceable, and the patient himself is incapable of giving consent. Now, the last part of my presentation would be on the exception where consent may not be required. And they are actually two exceptions under these circumstances. One, when there's a court order where there's a specific court order to mention, like certain treatment need to be given to a particular minor where the patient is actually on life support. There may be cases where a patient may refuse treatment or life-saving procedure, for example, on the blood transfusion, etc., based on the religious or native custom. And in this regard, if the practitioners were to face with this kind of scenario, it is advisable for the medical practitioner to obtain a court order, provided that it is not an emergency situation. In cases where medical emergencies, the consent is not required, where immediate treatment is necessary in order to save a person's life, or in order to prevent serious injury to the patient, in which in this regard, immediate procedure needs to be done, and the consent is not necessary at that point in time. Secondly is that when there's no unequivocal written direction by the patient to the contrary, in this case, like example of this is that where there's a written direction, also known as living wills or advanced care directive, in which I believe this would be in another topic that require further discussion. But if the medical practitioner is aware of any written direction from the patient, and in which that particular written direction is not clear, it would be best for the medical practitioner to seek legal counsel advice and to act in the best interest of the patient in the meantime, and to obtain a court order on the matter if necessary. And thirdly, where there's no relative or any legal guardian available or contactable during the critical period to give consent, a consensus of the primary surgeon or physician who is managing the patient and a second registered practitioner is to be obtained. the primary surgeon or physician signs a statement with the consent from stating that the delay is likely to endanger the life of the patient, and the second registered medical practitioner must co-sign the consent form to confirm the position. Basically, that would be the gist of my presentation today, where I've addressed the definition of consent, who is responsible in obtaining consent from the patient, the validity of the consent in terms of the duration, the features of a valid consent when there are 6 features, i.e. it must be voluntarily, it must be an informed consent, it must be in written form, there must be a witness, and the patient must have mental capacity in order to give consent. And I've already elaborated on the exceptions where in an emergency situation and also otherwise. So with that, I conclude my presentation today. And I would like to impress that consent is pretty important um, to be obtained before any procedure, examination, surgery, treatment is done. Failure to obtain or to record the proper consent may lead to issue arising such a failure to advise of risk, allegation of battery, assault, etc., in which I can confirm that on the medical legal cases, we can see apart from the issue on the care management provided to the patient by the consultant, consent is actually the other issue which patient is harping on in basically what we call that to argue on the care management given by the consultants to the patient. So with this, I shall conclude my presentation and I shall open for Q&A.
Thank you very much for the very succinct and comprehensive talk, Puan Fazliza. So that was a recorded talk. So I'm going to invite Puan Fazliza onto the stage now, and then we will begin the Q&A. So you're on stage now, Puan Fazliza. How are you?
Yeah, I'm fine. Thank you. Good evening,
Okay.
everyone. Yeah,
Yeah.
earlier during my pre-recording, I did mention that my managing partner, Mr. DJ Chan, may be joining us, but unfortunately, he couldn't make it today. It turns out to be he needs to fly to London for work purposes, and perhaps in our future sessions, he may be joining us. So we apologize for that.
Okay. There are questions which are coming in from YouTube, and also questions from our preferred uh, channel, which is Slido. So maybe I will take you through some of the questions from Slido first. Okay, will that be all right,
Yeah,
Lisa? I think
sure, Dr.
you will share the Slido tab so you can see the questions there. Um, so there's first question from Anonymous. Must the witness be uninvolved? As most times the doctor's nurse is usually the witness. I guess what the person is asking whether it's impartial or not part of the care team.
Yeah. You see, when the issue of consent, it is actually an issue under the medical legal methods. Most of the time, we will ask the consultant to testify in court. Perhaps for the consultant to explain to the court that this is the consent form which I've obtained from the patient. There's a risk and complication being addressed in the consent form, and there'll be a witnessing part. I understand as well, for convenience sake, in terms of the practice, the nurses who is assisting the consultant, they will be the witnesses. All right. So in the event that the matter being escalated into court action and the issue is purely on consent, apart from that particular consultant, the nurses who witness the consent making process, they should be called as a witness as well. At the end of the day, the argument that the patient's going to make or raise before the court, like since this is a nurse, which work together with the consultant, there's always a possibility that this particular nurse tend to protect the consultant. So that would be their main argument. And I can understand that it is very difficult, or it's not at the end of the day practical to get someone else to be the witnesses. But this is the what we call that approach taken by the patient in order to refute the consent taking process by the consultant, which has been witnessed by the nurses or someone known to the doctor. So that answers the question.
In your earlier part of the talk, you mentioned about the MMC definition of consent. It actually, if I recall, it doesn't actually mention a witness. I mean, how compulsory is it for there to be a witness signature? Sometimes some procedures are quite straightforward, like for example, blood transfusion
Yeah.
or something else. Is it really stated anywhere black and white, and must it every type of consent be witnessed?
Basically, like it can be seen from the my slide on the features of a valid consent, where at the end of the day, there's one. Phoebe, can you just share the slide, please?
Let me see whether the presentation is still there. No. Phoebe is Faciliza's legal assistant. You can't share yet, Phoebe. I will bring you on the screen. Okay. All right. Go ahead and upload the slides again, please.
Phoebe is actually the junior partner in the firm.
We did the recording in a separate session, so the slides were uploaded there. Okay.
Features of a valid consent. First, it must be voluntary and personally given. Secondly, it must be an informed consent where the patient must understand before he gives the consent. Third features would be it must be written and recorded, clinical notes and etc. Then there must be a witness interpreter to attest to the process during taking of the consent. So this is one of the feature that would make a valid consent. And in terms of witnessing, is quite important because at the end of the day, if the issue of consent being raised in court, it is more the consultant's word, the doctor's words against the patient's word. So that's the reason why we need the third party, basically to support, yes, there's a process to it. Yes, the patient consented to the procedure.
Okay. Another question on consent is it necessary to list all possible complications related to the procedure?
At the end of the day, what is important for the material risk to be explained to the patient? It's not necessary for the consultant to list down all the possible complication. What is required, it is only on the material risk. And that material risk, actually, it differs from one individual to another individual. In view of this, like at the end of the day, that's the reason why currently for the court, it is more towards patient-centric, in which the court would expect the consultant to have a conversation with the patient to understand in terms of their background, their occupation, what is important to them, in terms of their lifestyle and all that. So with that so-called the background checking, and you get to know your patient, that would entail the consultant to be able to at the end of the day highlight what are the possible complications. It's not necessary to mention, like all the complications. Usually we would only highlight it to the patient what is material risk. In fact, for material risk, it will be a different topic. Like in fact, under the law, even when you go to court, and even when we engage with an expert, there will be a specific topic: what is material risk, what need to be communicated to the patient, and what not to be communicated to the patient. Because we truly understand that, like in order for the consultant to explain each and every possible complication, it will take some time. But usually for the court, they won't accept this kind of excuses because to them, at the end of the day, you're providing health facilities to the patient. There must be like some sort of communication, patient-centric. You need to understand the patient. And, like if at all, you need to highlight what are the possible risks or material risks towards the patient. And all that, it must be stated clearly in the consent form in order to avoid what we call that further dispute in future. Like even on the success of the procedure, I've seen, like some consultant, they decided to put like 80%, 90%, or, like if at all for this particular risk to happen is about between 10 to 30%. So at the end of the day, all this must be incorporated and it must be stated clearly in the consent form. Because when it comes to the issue of consent, the opinion by a third party, which is the expert, is not required because it's based more on the facts finding what happened on that day, and is for the judges to decide whether in terms of the consent taking process that is sufficient or otherwise. So for that, for the judge to decide on that consent taking process, third party opinion, which is expert, is not required, where the judge can make his own facts finding based on the documentation presented before him and also the evidence given by the witnesses, for example, the nurses who witnessed the consent taking process by the patient or by the family members of the patient.
What exactly constitute material risks? Is it only what is relevant to the patient, or is it a certain percentage risk to
What is relevant to the patient? For example, by undergoing certain procedure, there's always a possibility that like this particular risk will happen, A, B, C, D, and D. Like at least you need to list down about 5 to 10. Depending on the, what we call that, the condition of the patient, what was presented, and that particular risk, like need to be explained and need to be stated clearly in the consent form. Or at the end of the day, in terms of the rate of successful, whether it's going to be 80%, 90% recovery and that kind of thing. If the consultant feels that this is important and this being asked by the patient, then it needs to be stated clearly in the consent form.
I have always this thing I just ask, death, I suppose, is a material risk and nobody wants to die in any procedure, right?
Yes.
But at the same time, if we mention the possibility of death on each and every procedure, I don't think we'll get much procedures done. For example, let's say if the patient has a treadmill, exercise ECG, do we have to say your risk of dying during the exercise ECG is 1 in 10,000? Or if I do a bone marrow examination, already people are very scared of the pain. If I tell them there's actually a recorded material risk that 1 in 50,000 bone marrow examination end up in death. How many people do you think will agree? What's their concept of 1 in 50,000, 1 in 100,000? They may have no idea. But then in the court of law, you say you did not mention it. If somebody kena the 1 in 50,000 and then the patient died due to some severe allergic reaction or something and then happened to die, then we didn't mention the material risk of death. Is that a
It's not.
omission?
At the end of the day, it's not so much about highlighting the risks of death. It is more on the if at all, what is the side effect in the event that you decided to go for this particular procedure. And in the event that you're having like this patient having a cardiac arrest, 80 years old lady, is it necessary to go for angiogram or even like the balloon procedure? So with that, taking into consideration the age and also the underlying condition, what is the successful rate? And with this, when you explain to the patient or the family members and knowing the rate of success or what are the, what we call that, what are the sequelae and etc., then that's where the patient can decide and for them to basically make an informed consent. So in the event that there's any issue, they cannot finally decided, what, this was not explained to me. I'm not aware. Therefore, I decided to proceed with this particular procedure. Okay. And I don't really agree because there are certain things not being highlighted. Of course, in the course of the trial, we will try to establish, before the witnesses, do you agree at that point in time? We have already mentioned and you decided to proceed with the procedure. And now since you have recovered and all that, so basically there's an afterthought that, this thing should not be done. But at that point in time, that was your intention. So this is the facts where we try to establish in the course of trial. But consent per se, it is actually for the judges to decide. They need to know whether, as a treating doctor, you have already disclosed all the risks or the material risks to the patient to enable them to make an informed decision in agreeing for certain procedures being conducted.
Okay. Dr. Gan asks, what about unknown complications at the time you take consent, which are later on only described in journals? Is the doctor still liable?
No, I mean, at the end of the day, it's unknown complications. So we are treating it as not material risks. Therefore, it's not necessary at that point in time for the consultant to basically inform the patient that this is the side effect, this is the risk. So if at all on the unknown complication, we will get an expert to testify, to prepare a report to confirm that this is actually an unknown complication. I mean, no one can predict that this is going to happen, but it's just that so unfortunate that it really happened to that particular patient.
Doctors don't have a crystal ball, so we can't predict what in the future might bring.
Yes.
Dr. Faisal asks, is there a difference in consent between the patient if there's a difference, between the patient who is mentally capable and the next of kin? So who do we follow? We still follow the patient's wish and consent?
We should follow patient with is mentally capable, because at the end of the day, the patient should decide and the patient should give the consent in terms of the procedure to be undertaken. We have come across cases where the patient, like for example, being a mother, not so educated, she just leave it to the daughter to decide. It's just that the daughter studies in overseas, like they are well versed. I mean, like they can just Google or do their own research and whatnot. So in that circumstances, even before the court, the consent given by the daughter, the so-called educated daughter, is not good enough. It must be a consent directly from the patient. So like
Can I give another
yeah.
a circumstance? Say it's a woman who consents to tubal ligation, but the husband disagrees.
Right.
So what do we do in such a
Okay,
circumstance?
in that circumstances, it must be from the patient, because we have come across a situation where the husband being so dominant, and at the end of the day, the husband tend to dictate what needs to be done and otherwise. And in fact, we have come across cases where husband decided to sue the hospital and also the doctor in view of certain procedures being performed. So when the wife took the stand, we know at the end of the day, she just leave it to the husband to decide accordingly. So for that particular matter, the judge called her in chambers and asked her one-to-one without involving the husband. So she make it very clear in chambers before the judge and also the lawyers. Actually, I would not want to pursue, but it's just that my husband being whatever. But I cannot, at the end of the day, say this before him and all that. So the judge called up the husband, seeking further clarification on that. So at the end of the day, it doesn't really matter who's dominant. The consent must come from the patient directly, and the patient must agree to whatever procedure being undertaken, because at the end of the day, it's on her body, so she need to consent to it. If not, it will be a trespass. Then there will be another subject matter, you see, like trespass to body or battery to body and that kind of thing.
Okay, thank you. Now, the next question, we have to move on because quite a lot of questions, is should the consent be taken by the doctor doing the procedure?
Okay, for this, it is depend on circumstances. Why is it the consent need to be taken during the procedure? Why is it cannot be prior to the procedure?
Can a surgeon, for example, delegate a junior doctor to take the consent? The surgeon is the one doing the procedure. Yeah.
Yeah, it would be the surgeon himself, because at the end of the day, as I highlighted earlier, nowadays the concept that the court is approaching or applying is more on the patient centric. So there must be some sort of communication. So why is it you are delegating that particular task in obtaining consent, which is quite important, to a junior doctor. So whoever perform the surgery, that particular person shall be taking the consent from that particular patient. It cannot be
Okay.
delegated to a third
Mm,
party.
mm, mm. Advice on process if the guardian, not parents, refuses to give consent. I suppose this is for a minor.
Well, if this is the situation, at the end of the day, there must be a clear notation in the medical record that the consultant had advised the guardian on the implication of not proceeding with a certain procedure. And at the end of the day, the guardian acknowledged the risk and decided not to proceed. So all this is must be properly documented and also noted in the medical record, because we wouldn't know 5 years down the road, like whoever decided to sue for whatever reason. So we know at the end of the day that record is there um, for 5 years ago or whatever. So there's no such thing as that particular record entry being tampered, or someone just like to add on some entries in the medical record just to explain on that particular matter.
Okay. Confirm that consent is not required in clinical trials is stated in your slide. I may have missed that part. What's your comment about slides? Let's see. Uh, I don't see anything about not required conventional treatment apart from surgery, electroconvulsive or clinical trials. Consent not required. Top line in the slide. It's apart. I think it's apart from surgery. So we are talking about conventional treatment apart from surgery, ECT, or clinical trials, not
Yeah,
including clinical trials. So I don't think you said it wasn't.
yeah,
Okay,
correct.
we will skip that. Yeah. All right. We move on quickly. Does e-signature, digital signature valid for consent form in these days of electronic medical records?
Yes. So when it comes to the electronic medical record, because I believe it is still new, even for the judges. Like for us, we have been representing the hospital and also consultants, so we know how it works. At the end of the day, it is more for like the consultant need to explain to the judge how it works. In terms of the consent taking, it is actually done physically, face to face, and all that, but it's just that when it comes to signing and whatever, it is actually by way of e-signature, and we need to explain the process, how is it done, can like anyone just access to the system and that kind of thing. Because my understanding is that like each consultant, they are provided with a different code, and no one can access like to the system, and the dates and times, everything is digitized, so there's no way of that particular entry being tampered or otherwise. So it's just that it requires much more explanation by the consultant to the judge to explain how electronic medical records works lah. Because there's no physical copy to begin with for us to explain to the court. So we just need to, like, yeah, as I said, that it will require more explanation. But yes, it is acceptable.
So we don't actually to have paper consent form which are scanned. And some hospitals don't use electronic consent form. They still insist on paper consent form signed and then they scan it into the system. So that actually, and then it ends up from a paperless system to actually not truly paperless. We end up with stacks of consent forms in the
Yeah,
medical record still.
correct.
So you're saying it's not really necessary to be paper, it can be electronic.
Yes,
Mm.
but it's just
That,
that when it is electronic, in the event that matter escalated into court, then it will requires a lot of explanation, because like I mean, for the judges, they're not really familiar how does it work. So like you need someone to explain, or even for the consultant must give a good explanation in order for the judge to understand how does it work.
so we just need to document that we've explained
Yeah.
inside the records. I think there's a similar question in YouTube, so I think we'll consider that covered because we have really a lot of questions. We need to move on. Dr. Aisha asked if the patient is in his teens but under 18, is mature enough to give consent for simple procedure like X-ray, IV meds. Is his consent valid even without parents?
No. Basically, below 18, they are considered as minor, and therefore, they are not able to give an informed consent. So you still need the consent of the parents.
We will some of the consent comments rather than let me change the order. Sorry.
Okay.
What if the next of kin is refusing the life-saving procedure in an unconscious patient? Can the consultant overrule the decision for in the best interest of the patient?
Is this pertaining to a life-saving procedure?
Yes, but the next of kin refuses and the patient is unconscious. One ethical dilemma.
Yeah. I mean, at the end of the day, well, I believe that, for that particular consultant, they must, at the end of the day, understand what is the reason of that particular next of kin decided not to proceed with the procedure. Is there any particular reason? But because whatever it is, as I mentioned, notation in the medical record is really important. So, like for example, even the next of kin decided not to proceed with certain procedure, there's always a possibility that other family members, like start to query why is it you did not do this and that. So it is more of an ethical issue, and at the end of the day, there must be like some sort of like investigation needs to be done to know what are the reasoning behind that particular decision, whether it is going to cause further side effect where even if the patient were to recover and subsequently the condition is going to be deteriorated, like it cannot recover fully. There must be a reason to it. So we need to establish what's the reason, and again, it must be clearly noted in the medical record for future
Dr.
reference.
Z is a question and comment. Minor under 18 diagnosis made by treating doctor. Parents refuse to accept diagnosis, verbally abuse and threaten to sue. And then second doctor and others also facing issues, disease, infectious and contagious. We need to notify health authorities. I'm not sure the consent here is related to what? Consent to treat or consent for notification in particular types of infectious disease. I don't know
Because
what the
it seems here that it involved a minor patient and in which the patient refused to accept diagnosis and treatment.
the parents.
Yeah, the parents.
Hmm. What
Can
should
the
the doctor do?
their decision to best interest of a patient?
Consent
Well,
to treat. Okay, consent to treat. Yeah.
at the
Okay.
end of the day, as per what I highlighted, in the event that the patient is below 18, the best person to give consent is actually the parents. And in the event that the parents decided to give consent for whatever reason, first of all, we must determine what is the reason. And there must be a clear notification or notation in the medical record on the basis of the refusal. As per what I highlighted, in the event that consent was not properly obtained, the apart from, if it's not so much on the medical legal aspect, there's always a possibility where the consultant will be sued for battery or assault, because at the end of the day, I did not give you consent to, like if at all to give the treatment to infringe my body, but you decided, although not me personally, but like it is my kids, and that's where I decided. Because like we encountered a case where consent is an issue and subsequently the patient say I did not consulted to it, and the patient decided to sue the doctor for assault and also battery, which is not related to medical negligence. So it is the other aspect of it.
Okay, we have to give chance to some questions in YouTube. So we've got 5 minutes actually more, but we will try to answer the questions. So John Doe asks, what steps can be taken to address power imbalances and ensure the consent is truly voluntary in cases where the patient may feel pressured to comply with medical recommendations?
Well, at the
I
end of the
suppose it's
day,
maybe. Yeah,
Well,
go
at the
ahead.
end of the day, I believe that perhaps there should be a consultation session with the patient. And, like for that consent taking process, it should not be taken immediately, perhaps to give some time for the patient to consider. As per what I highlighted under the MMC guideline, as long as the condition, there's no changes in terms of the condition, therefore fresh consent should not be taken. But under the law, the reasonable period, deeming period is between 7 to 14 days. Perhaps, the consultant can decide to fix another appointment after 2 or 3 days, just to make sure that the patient is not under any pressure to give consent to any particular treatment. It's not that it need to be done then, like if it involve non-emergency cases lah.
What if the patient is in a vulnerable group, like prisoner or illegal immigrant or something? Any other steps
Illegal,
which, yeah,
other steps meaning?
how to ensure that the consent is truly voluntary, so there won't be any dispute later on.
Oh, as I
I
said,
please, yeah.
time can be given if it's not in an emergency situation. Like perhaps I'm gonna inform you of this procedure. These are the risks. This is the potential risk. So why don't you think about it? Then perhaps come back after 2 days' time and let me know
Mm,
whether are you
mm,
agreeable. Then you need to ask the patient to sign the consent form.
okay,
So at least
okay.
ample time is given, rather than say that you must sign the consent form now. Then.
How should we handle the situation when the patient initially expresses consent, then later on change their mind during the course of treatment?
Actually, it is quite rampant, lah. So that's the reason why, although the patient consented to a certain procedure or treatment, subsequently they decided to sue the doctor for not obtaining a proper consent. Before at the end of the day initiating a certain procedure. When it comes to medical negligence, what is important is actually a notation in the medical record. So in the event that initially the patient consented, therefore we proceeded, and subsequently the patient changed mind and decided, like to stop whatever treatment. So there must be a clear and proper notation in the medical record, that the patient decided not to continue for whatever reason. And in view of this, we have already advised on the potential risks in the event that the patient decided to stop the treatment. So this is whatever being advised. I think that should be enough, because when it comes to human being, there's always a change in position. Like one day you would like to do this, the next day you decided this is not what I want. I would like to do something else. So in view of this change of position, there's a lot of medical legal cases being fought against the doctors and also hospital. It's just that they just tend to change their mind, like one day they're saying this and the next day they're saying otherwise. I'm talking purely about the consent taking procedure. Like, it's not so much on the care management and negligence in that aspect.
This one, maybe the GPs will be interested to know, is consent necessary before you give the patient an injection because of possibility of severe anaphylaxis?
Yes, because like whatever procedure that needs to be taken, consent must be given, and even a simple injection and whatnot, like in terms of the risk, it must be highlighted to the patient so that they are aware
I
that,
see.
okay, this is possible. Yeah.
Would it be implied consent be enough, or must it be written? I mean, we give IV antibiotics all the time in hospital.
Yeah,
Then
because
we give a
because
new
at the end
drug.
of the
Yeah.
day, well, as per what I highlighted, the 5 features of a valid consent, like it must be in writing, so there must be a witness, a clear explanation. So that's the 5 features lah. So yeah, I know at times I say that, it's just a simple procedure, injection and whatnot, but as I said, like it's more like patient centric. So the court expected the consultant to have like a session with the patient to let him know if this is the thing, this is the complication, even like reaction, allergic and all that. Because like apart from those specialists being sued, recently there are quite a number of cases against the GP clinics as well. Like in terms of giving an injection, then it caused reaction, and in view of that, they're asking about 100,000, 200,000 aggravated damages. So in order to avoid all that, so it is good to have a proper consent taking process. At
Is
least
it not good
everything is
enough?
there.
We document in the notes that we advised so and so go on these antibiotics, and we counsel about potential allergy and all that. And patient agreed to cope. Do we need to have a special consent form just to administer an antibiotic?
Well, I mean, at the end of the day, the patient's going to say that I did not sign anything. It's just a self-serving documents, like you can write whatever things that you want inside. Anyway, it's just a small clinic, so you can always tamper with the documentation, the entry. No one knows, because when it comes to hospital, there's what we call that. There's a strict rules as to when the consultant can access. But for clinics, usually to them, like you can just write whatever things that you like lah, unless it is actually what we call that is actually an e-medical record, because I know for some clinics they do adopt this, and there's no way, like at the end of the day certain entries being amended because the date, the timing and everything is fixed. So that, yeah, there's a room for argument. If just using the old method, just a paper and all that, so it will raise a lot of issues
Okay, we really must move. Taking a lot of your time, but a lot of questions. One, Fazliza, sorry.
Yeah,
How to
I
deal
know.
with minors?
It's okay, no problem.
How to deal with minors who seek STD screening without accompanying legal guardian and refuse to disclose the matter to his or her parents, guardians?
The provision is that below 18, basically consent from the parents or from the guardian are required. So that's the law. It doesn't really matter whether, like they refuse for the parents to know, but at the end of the day, law is law. Age of majority,
Mm,
18 and above.
mm,
So we must
mm.
stick to that.
Okay. Doctor, obstetrician asked this question. The husband comes with pages of do's and don'ts to the pregnant wife soon to be delivered baby. No vaccines, no episiotomy, no painkiller, no cesarean. What to do? Did they say go see another obstetrician?
Yeah, because at the end of the day, as I mentioned, perhaps
Mm,
like like you need to have a session with the wife. I mean, that kind of thing to explain this is important. And in the event that it is very difficult for the doctor, the ONG to perform his duty in view of all this restriction, then it's best to discharge from continuing, because you can see even now there is an issue. What more, in future? Because like we do have matters as well where the husband prepared a list to the ONG before delivery. You need to do this and that. Then of course the ONG decided, okay, I'll try my best, because it seems that first delivery there's not an issue to begin with. Who knows, second delivery there's a complication. So whatever listing A, B, C, and D, of course the ONG did not manage to follow exactly lah, and because of that they are not happy, and they decided to, not so much in terms of medical legal, but they decided to complain to the MMC, to say that like they have already set their mind this should be done A, B, C, and D, but it's just that the ONG decided not to follow the sequence, and in view of that they just, for the sake of complaining, just to make things difficult for the consultant, just drag her to the MMC for inquiry.
Okay. One last question, I think, before we conclude Q&A. For health screening to minors, but only non-invasive, for example, a questionnaire, but includes sensitive questions such as sexually related matters, does it still need to be consented by the parents?
Because at the end of the day, when it comes to minor, which is below 18 years old, parents' involvement is required, because under the law, they are not capable in deciding or even like to form their opinion. So that's the reason why under the law, it is clearly stated, minor below 18, you cannot decide. If anything, like you still need the consent of your parents or your legal guardian.
Yeah. Okay. I think we've gone past our time. There have been some comments. For example, Dr. Ho says, excellent presentation, clear and concise. So I think we want to echo that sentiment. I think Puan Fazila, it's been very clear what you've delivered today, and it's a very important reminder on the consent taking procedure, having witnesses, material risk explained, etc. And then also for minors and those who are incapacitated, what to do, and so on. And the Q&A also, I want to thank all the participants for um, putting forth their questions. I think maybe may have missed a few, one or two or few out there, but we can't answer everything. Okay, so we come to the part where we end and we just want to show you the QR code. So doctors, I don't know about lawyers, but doctors have to have points to be able to practice, and it's mandatory 20 points per year, which begins 1st of July until 30th of June the next year. So this month is the last month for you to accumulate 20 points. Okay, otherwise, no APC for you guys. If you are not watching live, just a reminder, you can go into our forum and answer the MCQ. So the link to the MCQ is down below the video in the web page. Yeah, if you're watching the web page, so you click, it will take you to the forum. For the dentist, you click on register for CBD points, and the Private Dental Practitioners Association will help you get the points. Now, when you click on the forum, you'll be taken to the MCQ module. I just show there are also some previous modules which are still valid until 30th of June. Puan Fazila actually gave the talk. I just repeated it, and that's the Insight to Medical Disciplinary Procedures. You can watch it. Aggravated and exemplary damages and challenges doctors face, and then today's one. So there's 4 CBD points for you to claim. Say you are running short of 20, you can still go there, click, and then you go to the MCQ module, which looks like this. Click on the solve online, and you just need to answer the simple questions, and you automatically get the point. Okay. So that's 4 points if you haven't taken this before. If you scan the QR code and then also do the MCQ, you won't get 2 points. And the system is smart not to double register the points. You get only 1 point whether you scan or you answer the MCQ. So you cannot game the system. I'm sorry. So without further ado, I want to share the QR code. So let me make it a bit bigger. Oops. Okay. Have you all got the point? Can you let me know in YouTube live chat if you got the points? Let me check it myself. So as I mentioned earlier, the MMA app has been updated, and make sure you have downloaded the latest, yeah, so that if you're watching on a mobile phone, you can take a screenshot of this QR code, and you should be able to uh, save it onto your photo gallery, and then when you open the MMA app, instead of taking the scan from your camera, you can click on gallery, and then you can scan the saved screenshot. Okay, hope it works for you guys. Okay, so I think we've come to the end. Please don't forget to like this video, share it with your colleagues who may have missed it. They still have time to watch, and until the 30th of June, you can still claim the points by answering the MCQs. But more important than obtaining CBD is actually learning. I think that's what all this is about. And medicine is a lifelong journey about learning. And every time we sometimes need reminders, because we also forget as we get older, and we need reminders and reinforcement on what the important things are in our practice, especially from the medical legal angle. So thank you once again, Puan Fazliza,
Welcome. Thank you for
spending the
having me.
time. Yeah,
No problem.
and we look forward to having you again in a future talk.
Sure.
So We wish you everyone a good night, and thank you. Sorry that your partner couldn't be, but anyway, wishing him safe journey to London, and thanks to your legal assistants for their their help. Okay, so good night, everybody, and have a great week ahead. All right, thank you. We're going to end the broadcast now. Don't forget the code is still valid for until probably until 9:30 to 10 o'clock or so. But if it's no longer valid, you can take the MCQ module. If you're a doctor, if you're a dentist, just submit the registration form. Good night, everybody.